My name is Denise Harlow. I'm with the National Community Action Partnership, and thank you so much for joining us on today's webinar. Head Start, as we know, has gone through quite an interesting time recently. We know that it was reauthorized a number of years ago, still during President Bush's administration back in '07, and I know we've been awaiting the proposed rulemaking coming out of that reauthorization, and here we are close to the end of the Obama administration with the proposed rules coming out for Head Start. What will change, what will be modified, what impact will it have on programs, staff, governing boards, and policy councils is significant. I know that the NPRM is quite the lengthy document, and while today we're going to be walking through some of the core elements of the NPRM, there's still going to be a bunch of information that we probably won't have time to get to. I know that we hosted a webinar probably 2 or 3 weeks ago with Ann Linehan and her team from the Office of Head Start, and she also did kind of a high-level scan of the NPRM, which was very helpful. That is recorded up on our website if you missed it. And at our convention, we know we're going to be having Dr. Enriquez, the director of the Office of Head Start, along with Yasmina Vinci from NHSA, join us for the Head Start Town Hall. But that meeting will be after the deadline for public comment on the NPRM. So there's a window of time here to make sure that CAP agencies that have Head Start embedded within them are attuned to what's going on within the NPRM. Again, we aren't going to be able to cover everything, but we hope we at least get your interest in certain categories. If you haven't already done a deep dive, perhaps you will after today. My guess is many of you have done at least a cursory read of the NPRM, or at least some summary documents of it, to give you a sense of what some of the changes that are being proposed are. So today we are joined by our friends at CAPLAW. It's great to be able to do this joint webinar for the network. CAPLAW are our thinkers and our lawyers in community action. We're thrilled to have them be an asset and a resource to the whole network, and we're thrilled to have them with us today, co-sponsoring and probably doing the bulk of the teaching on today's webinar. There is a chat window, lower right-hand corner of your screen. We encourage you to please put questions as they come up into that chat window, including comments that you might have. I know that CAPLAW will be talking about this, but I know they're welcome to receive comments from you. I know they would like them, I believe, by August 12th. They are planning on submitting comments. Here at the partnership, we are also considering putting in comments to the Office of Head Start. And so following today's webinar, you will get a copy of today's PowerPoint presentation, a link to the recording, because we are recording it, and then a link or a copy of CAPLAW's current article that they just issued, I think, earlier this week in their e-news. If you don't get their e-news, I encourage you to subscribe. It's a great resource. And then we'll follow up, probably following this webinar, with what can we do to tease out where the big areas of concern are. The Office of Head Start is not looking for 100 letters talking about the exact same thing. I know that they want to make sure it's as streamlined as possible. So if there's a way that the partnership can sign on with CAPLAW or add a supplement to what CAPLAW is providing, or even NHSA, that reflects what community action needs, we want to be able to do that. So we'll certainly be in touch with you going forward as well on that process. So again, we are recording. Please put questions in the chat window. We are going to be turning it over now to CAPLAW. We're joined by both Eleanor Evans, the Executive Director, Chief Counsel over at CAPLAW. In addition, Veronica Zhang is one of their newer attorneys. Veronica, though, has taken the bull by the horns. I've run into her at a few things across the country, and she's doing great work. So we're thrilled to have Eleanor and Veronica with us today. So with that, I'm going to turn it over to you, Veronica. I believe you have the ball, and the slides are yours. Thank you.
Thanks, Denise. Hello, everyone, and thank you so much for the opportunity to do this webinar together with the partnership. We thought at CAPLAW that we would just walk through some of the major changes to each section of the NPRM. And we'll start with just a high-level overview. As many of you know, HHS published the Notice of Proposed Rulemaking containing the new standards on June 19th, 2015. And these represent the first comprehensive revision and reorganization of the standards since they were first published in 1975. HHS essentially reorganized the standards into 5 new sections, and we'll go through each of these sections. The parts are listed on the screen for you, and the comment period is currently open, and CAPLAW does intend to comment on the new standards. Eleanor will be chiming in on a few of the comments that we've already been discussing here at CAPLAW, but as Denise mentioned, if there's anything that you specifically would want to see in our comments or would propose for us to include, if you could just include those in the chat window at the bottom of the screen, that will be helpful to us as we prepare our comments. And also, if you have any more detailed comments and that you'd like to send us via email, please do so by next Wednesday, August 12th. And you can send them to me, and my email address is on the title screen of the slides. So before we get into the standards themselves, we'll just talk a little bit about some of the inconsistencies in the effective dates of the standards. There's a question of when the final performance standards actually go into effect. The section of the preamble that's entitled Effective Dates, which is 35502 of the NPRM, says that the standards would go into effect 60 days after it is published as a final rule in the Federal Register. And there's going to be a 12-month delay for certain sections of program operations, or Part 1302. However, the section of the preamble to Section 1302.103, that's the column on the right of this chart, says that HHS expects that the final standards will be effective one full program year following the publication of this NPRM, and that suggests that the final rule would be released approximately mid-year of 2016. Unfortunately, the text of the standards themselves don't indicate when the final rule would go into effect. So that's one inconsistency that we've noted and intend to comment on. The second question we have surrounds the one-year extension option. So there are certain sections of the NPRM that HHS has indicated would be subject to a 12-month extension. In the effective dates section of the NPRM preamble, there's an automatic one-year delay of a number of sections, and we've listed them here on the screen. These cover both the extension of the program day and program year requirements, as well as requirements that cover, for example, staff training and professional development, some curriculum requirements. And in the effective date section, HHS essentially says that these sections would be automatically delayed for 1 year following the effective date of the final rule. So agencies wouldn't have to petition HHS for an extension. However, in Section 1302.103C, some of you may have seen that the language there essentially puts the onus on the grantee to petition HHS for a 1-year extension to meet specific requirements, and you have to show that the extension is necessary to ensure that currently enrolled children are not displaced from early Head Start or Head Start programs. The sections that are covered by the 1-year extension in this section are just the three that are listed on the screen, and these are the extension of the program day and program year for center-based, family-based, and home-based options. And so, again, CAPLAW in its comments, we expect to ask HHS for clarification around both the effective date question as well as whether the 1-year extension is automatic or requires a petition to HHS and the sections that they would cover. So now let's walk through each part of the new standards. Again, note that just due to time constraints, we're not going to be able to give you a comprehensive summary or even a complete list of all the changes that HHS made, but hopefully we're highlighting some of the ones that are that we've identified as important and that in our conversations with folks in the network, people have indicated to us are important to them. So looking at program governance to start off, the section on the governing body, the standards essentially reiterate the Head Start Act language that says that the governing body has legal and fiscal responsibility for the Head Start agency, but instead of listing the governing body's roles and responsibilities, the standards just point to the responsibilities that are listed in the Head Start Act. The standards also allow the governing body to establish an advisory committee. This committee would oversee key responsibilities that are related to program governance. However, the governing body would be required to develop written procedures that describe those responsibilities.
And also, this is Eleanor Evans here, and I just wanted to jump in about a couple things about the governing body and program governance that we might comment on. So, first of all, we think it would be useful if they're going to reiterate the Head Start Act's requirements about the governing body, that perhaps they simply reprint those in the regulations themselves, because people may not be inclined to pull out the regs and pull out the act and read them side by side to look at what the different responsibilities are of the governing body and the policy council. And then even under the act itself, it's been a little bit unclear across the Head Start network about the policy council and its role in, for example, hiring and firing Head Start staff, because I think, under the currently existing performance standards, there is that the policy council has a pretty active role in that. And ever since the passage of the Head Start reauthorization in 2007, we initially thought that the Office of Head Start and the regional offices would take the view that the governing body had the legal and fiscal responsibility and that the policy council took more of a backseat. It appears that they're taking that position with the issuance of these proposed regs, but we would just like to seek some additional clarification. Also on the advisory committee, there's some discrepancies there, like it says to oversee certain responsibilities and that periodically it would have to report on its governance decisions, but then by the fact that it's termed an advisory committee seems to imply that it wouldn't have the opportunity to make decisions. So we're going to seek some clarification in those areas.
And as Eleanor indicated, the section that deals with policy councils do the same as the language in the governing body. It just simply references the responsibilities of the policy councils set forth in the Act rather than putting them in the text of the regulations. And the other sort of major change in this section is that policy council members are now going to be allowed to serve a maximum of 5 one-year terms, which is an increase from the current maximum number of terms, which is 3 one-year terms.
And also, we've heard some positive comment on that from some folks, but we would be curious for folks on this call to weigh in on that, if that's something that you'd like to put into the chat panel, if you think that extension is a good idea or not. Again, it's not a requirement that somebody serve for that long. It's just extending the opportunity for them to do that, and there could be concerns on both sides. I mean, one could be, well, we've trained folks and they're into it now, and so it's good to be able that they could continue their terms. But on the other hand, people may say, well, let's open it up and make sure that many people have an opportunity to serve on the policy council.
With parent committees, programs are no longer required to have them, but you may maintain them if you want. I think one thing that we noted is that the regulations omit reference to parent committees entirely, so we may want to ask HHS for clarification to state in the regs themselves that parent committees are permitted if programs want to retain them. The next section on impasse procedures. Impasse procedures outlined in the standards essentially make clear that ultimately the governing body has the final say. For us at CAPLAW, this is consistent with the requirements as well as our understanding that the governing body has legal and fiscal responsibility for the program, but we are interested in what members of the audience think about this and whether you think this reflects an appropriate balance in the relationship between the governing body and the policy council.
And one concern that we've heard from some folks in the field is that these proposed regulations kind of water down a little bit the parent involvement that has traditionally been part of the Head Start program. And so, at CAPLAW, we want to make sure that the Head Start program maintains what we see as its strengths in terms of, the parent involvement and the wraparound services, and, in addition, of course, to the high quality educational services as well. But if there are areas in the regs that you think are detracting from the traditional role of Head Start, we'd be interested in hearing that as well.
So moving on to Part 1302, which deals with program operations, the first section on eligibility determination. So as you may remember, earlier this year, HHS released new eligibility determination regs. They went into effect March 12th of this year. And after getting some feedback on the new rules, HHS is proposing making a few additional changes here in the NPRM. A few of those changes are they recognize that not all employees get W-2 forms, and so the proposed rules say that staff can verify income eligibility using any tax form or other proof of income and not just W-2s. Also, if eligibility will be determined on the basis of public assistance, the proposed standards say that staff must obtain documentation from a state or local public assistance office. And lastly, HHS added a provision allowing programs to request permission from HHS to use what they're calling an alternate method of determining eligibility. So this is a method that the program would develop on its own if they have other reliable data sources that would help them determine who should be eligible to receive Head Start services. Under enrollment, the standards are proposing a new provision that allows programs to reserve up to 3% of their funded enrollment slots for pregnant women or children experiencing homelessness or for children in foster care. And if this reserved spot is not filled within 30 days, programs would have an additional 30 days to treat the slot as vacant and then fill it as they would fill any other vacancy. Under the attendance requirement, I'm sorry, just to jump back to the enrollment for a second, one other new provision is that HHS is proposing that programs consider enrolling children who are funded through non-Head Start sources, including private pay, and the idea here is to create mixed income classes. And again, we've heard sort of different opinions about whether this is even helpful for children in Head Start classrooms, and we would be curious to hear what folks in the network have to say about this new, it's not a requirement, it's allowing programs to consider this.
And so I think our inclination is both on the reserving up to 3% of the slots for homeless pregnant women and children and for children in foster care, as well as the option to include, private pay children in the classroom, that, since they're not requirements, we think that, they could be good for perhaps for some people, maybe not for others, but if they're not good for your program, then you could opt not to take advantage of those new options.
Under attendance, this is a requirement that we've heard many programs talk about. Programs are going to be required to contact parents if a child is unexpectedly absent and is more than 1 hour late to class. And this, according to the NPRM, is HHS's way of ensuring that the child is safe. We've heard folks say that this is going to be incredibly burdensome, especially in places where during the winter, children may often be late arriving at programs. And so this is something that we'd be curious to get feedback on, but it is going to be a new requirement under the proposed standards.
And our sense is that, maybe they could require, one option would be to say that programs need to establish their own policies for contacting the parents if the child does not show up within a certain specified period of time. And I think that would be probably what CAPLAW would be leaning to comment on, but maybe programs have their own policies currently where they contact within X hours or something like that. So we'd be interested to, as Veronica said, to hear feedback on that.
Under attendance, if a child has 4 or more consecutive unexcused absences or is frequently absent, programs must also conduct home visits or make other direct contact with the child's parents. And if the child stops attending the program and the program has attempted to make this type of contact and is unable to contact the family, it's only at that point that the program can consider that child's slot to be vacant and to fill it accordingly. Under the new suspension and expulsion requirements, the standards really strongly say that programs need to severely limit the use of suspension and expulsion. They're really to be treated as a last resort only when the child's behavior poses a serious safety threat. And programs will be required to take exhaustive steps, and that includes working with the child's parents, a mental health consultant, the child's doctor, and other disability agencies to try to help the child return to the program. And it's only after the program takes these exhaustive steps that they'll be allowed to determine whether the child should be transferred to a more appropriate placement.
One thing that we noticed here is that they're focusing on suspension and expulsion based on the child's behavior, but they don't mention suspension or expulsion, presumably expulsion, based on the parent's behavior. And we know, we've seen CAPs with some situations where the parents are, being the way that they are comporting themselves when they're at the program is causing maybe other staff or children or other parents to be fearful, and so, you know, hopefully programs would have the option of addressing those situations and possibly, unfortunately, even by expelling the children.
Moving to the section about fees, the standards say that while programs cannot charge families that are eligible a fee to participate in the Head Start program, they can charge fees if the program is providing extra services. So, for example, when a program offers an extended day beyond the funded program hours, or for children who are funded with private pay or non-Head Start funding. So going into some of the program options, and here are some of the probably the most significant changes in the proposed standards. There are 3 standard program options under Head Start and Early Head Start. There's center-based, family-based, and home-based. There's also going to be a 4th, a locally designed variation of the 3 standard options that programs can petition HHS for. The home-based option, though, just to note, will only be a standard option for Early Head Start. So it will no longer be a standard option for Head Start, although a program could ostensibly petition for a locally designed variation that includes home-based visits or home-based care. Going to the extension of the program day and year for center-based programs, for Head Start, the center-based programs are now required to offer at least 180 days of planned operation per year, and this is going to be up from the current minimum of 128 days, and at least 6 hours of operation per day, and that's up from the current minimum of 3.5 hours per day. The Early Head Start requirements will continue to be at least 230 days of planned operation per year and at least 6 hours of operation per day. And again, just to note that agencies can seek a waiver from the extended program day and year requirements under the locally designed program option.
And certainly we think that this is probably an area where folks are going to have strong opinions one way or the other about this. Probably we're assuming that, you know, many Head Start programs, even if they offer close to, say, 6 hours a day, that there could be concerns about whether, you know, that this the way planned operation is defined in the proposed regs, it does appear that this is planned operation in terms of the hours that the children and families are actually receiving services, and wouldn't include professional development and other, you know, ancillary staff time that's critical to the delivery of those services. So we are a bit on the fence at CAPLAW about what, if anything, we may comment in this regard, because we think that across the network there may be, you know, people at varying levels of ability to comply or willingness to comply or interest in complying with this. I mean, obviously I think we would all be glad to provide as much Head Start services as, you know, we could, but I think the regs, you know, obviously contemplate, and there's a whole chart in it about the cost of the regulations. And as those of you who may have heard Ann Linehan speak or heard the Office of Head Start webinar, they estimate that all of the proposed changes would require an additional $1 billion of funding per year to do that, and the President had requested that in the current year's budget, I guess. But, you know, I think we're all cognizant that Congress may not come up with the money for that, and so then, you know, the question is what happens. And I think the message that I heard from Office of Head Start in their webinar was that, you know, if there is no additional money or not enough additional money, then that Office of Head Start would envision that the programs would decrease the number of children that they could serve to provide this level of service and to provide, you know, many of the other things that we'll be talking about here. So that is an area that folks may want to comment on.
Going to the next section on education and child development services, one of the changes to highlight here is the requirement that program instructional practices, curriculum assessment, and professional development have to meet the outcomes that are described in a new document. It's called the Head Start Child Outcomes Framework, Birth to 5. It's an updated framework document that incorporates 0 to 5, and this is a separate document that you can find on the Office of Head Start website. It was released concurrently with the proposed standards. Under services for children with disabilities, A new requirement is that programs must provide children who are waiting for the results of their IDEA eligibility determination with individualized services to the maximum extent possible. And then also for children who are not eligible under IDEA, the standards require that programs have to connect parents to needed support and services if that child demonstrates delays that are likely to impact school readiness. Going to the section on background checks and personnel policies, a new requirement here is that HHS is requiring programs to include fingerprinting for all Head Start staff hires as part of the criminal background check process. The criminal background check must also include clearance through child abuse and neglect and sex offender registries. And these checks have to be conducted for new staff prior to hire and for all staff members every 5 years.
And also, it's interesting because we were looking at this section which says before an individual is hired, a program must conduct an interview, verify references, and obtain the following to ensure child safety. And then they list all the background checks, the state or tribal criminal history records, including fingerprint checks, or an FBI criminal history record check, including fingerprint checks. And then, as Veronica mentioned, clearance through child abuse and neglect registry, and through sex offender registries, if available. And then the next section says that within 90 days after an employee is hired, a program must complete the background check process by obtaining whichever check listed above, meaning the state or tribal criminal history check or the FBI check, including fingerprints, was not obtained prior to employment. So we're a little unclear because first they say you have to obtain that check, and then they're saying that they appear to be giving you 90 days after in case you weren't able to get it. So we're going to seek some clarification there. We also want to seek some clarification where sometimes we know of, at least we're based here in Massachusetts, and we know in Massachusetts that under the state licensing rules, you can bring somebody on after they've gone through the background check and done a sex offender check and child abuse and neglect check, and then you can bring them on while you're getting the fingerprinting results, which here in Massachusetts can take a while. And that if there are any delays in that, it would actually not be necessarily within the responsibility of the Head Start grantee, but it would be at the state or the entity that's doing those checks. So we're thinking of trying to propose some language here that offers more wiggle room in terms of, if a grantee has done everything that's been required under their state licensing law to get the check, and they're just waiting to hear back, that that they could bring somebody on in the short term. So again, if people have experience with this issue and would like to share their thoughts on ways we might comment on it, we would appreciate that.
Moving to the staff qualification section, one of the new requirements here is for home visitors to have, at a minimum, a home-based CDA credential. And then HHS is also specifically soliciting comment on whether all Head Start and early Head Start teachers should be required to have a bachelor's degree, although just to note that the proposed standards don't actually include this requirement, so they're just seeking feedback on that requirement, and we at CAPLAW would be curious as well to hear from the network and to see if people think that that's a good requirement to include.
I think our inclination would be to say that we support teachers getting bachelor's degrees to the extent that it's required by the Federal Head Start Act, but if people have some feedback on that for us, that would be very useful.
On the training and professional development requirements, the standards here really focus on individualized intensive coaching for staff PD&T rather than intermittent staff training conferences and workshops. But programs will have some flexibility to apply to HHS for a waiver or an adaptation of the coaching strategy. And note that this is one of the sections that in the effective dates portion of the NPRM would have an automatic 12-month extension for programs to meet this requirement. Under the data system management and data governance section, a new requirement here, which is significant, is that programs must create what they're calling a data governance body or council. This body would be responsible for overseeing data management and data privacy, and also to set up data monitoring and accountability systems. This body would also be charged with integrating Head Start data into state longitudinal data systems. The purpose is to help states and Head Start grantees make data-driven policy decisions.
And this is something that we've been seeing not only in Head Start, but across the Obama administration, and even outside of federally funded programs in terms of expectations from funders around both, not only collecting data, but using data for continuous improvement. And so I think that their proposed requirement to create a body or a council, not to be confused with the governing body or the policy council, to oversee the use of Head Start data is just an outgrowth of that. But we see this as, while a laudable goal, that would seem to add a whole new requirement and then certainly new staffing commitments as well.
The last section here under program operations that we'll be talking about is reporting, and the standards really include a number of reporting requirements, but we just wanted to highlight two in particular that really jumped out at us. And the first is reports that are related to any risk affecting the health and safety of program participants. And I think there's some concern that that language is quite broad, and any number of things could be considered a risk that affects the health and safety of children or staff members. And then the second is reports on legal proceedings by any party that involve the program management, program staff, or volunteer as a party.
So yeah, two thoughts here. So first of all, the first one about reporting risks, health and safety risks. So the language says they would require reports as appropriate to the responsible HHS official immediately or as soon as practicable related to any risk affecting the health and safety of program participants. So we see a couple issues with that. First of all, it says as appropriate, but there's no definition of what is appropriate, and so we're a little concerned. On the one hand, maybe that as appropriate language is good because it could give grantees some wiggle room for saying, well, no, we did not feel it was appropriate for us to report that. It just, I guess, query who gets to make the decision of whether it's appropriate or not. Presumably, Office of Head Start, I would imagine, thinks that they would get that. But anyway, maybe we could put something in as appropriate as determined by the grantee. Anyway, and then related to any risk affecting health and safety of program participants. So at the moment, the proposed rule would go broader than requiring incidents, reporting health and safety incidents. It would require reporting of any risks, which obviously is much more broad than we think is necessary. Again, we're trying to figure out how to comment here in a responsive way, where we can see that they clearly want some kind of reporting, and obviously they're very concerned these days about issues of children being left unattended and things like that. But frankly, currently there is no requirement that one report those incidents. They have a program instruction, or maybe it's an information memorandum, I believe, from 2009 called the Safety of Children, which says that programs should report if they make mandated reports under their state's abuse and neglect reporting laws. But as we know from looking at the uniform guidance, the word should does not necessarily mean must. So anyway, there's no current requirement for this kind of reporting. And so, I think we would seek clarification to narrow this down, and if people have thoughts on how one might narrow this, one possibility is to require you must report if you have had, substantiated decision by your state, abuse and neglect, or organization that oversees investigates child abuse and neglect, or the equivalent, if there's been a proceeding and determined that the Head Start program has had a substantiated finding there, then that might be something that could be reported. And then the thing about legal proceedings that involve the program management program staff or volunteer as a party, well, first of all, that language doesn't even limit it to proceedings where that are related to the operation of the Head Start program. So, you could have a lot, technically under this, the way it's written, a volunteer could be sued, by a creditor for because they owe a credit card money and haven't paid them back, and technically under this, one would have to report. So again, in our comments, we're going to try to narrow down the situations in which one might have to report legal proceedings. So we wanted to stop here and take a break to look at what comments might have or questions might have come in.
Yes, we have been getting a few questions that have come in, which is really good. Let me just take a quick look here. Cashin wrote them down for me. Can you elaborate on the increase of operation days, hours per day for extension of the program day and year, such for instance, for center-based programs? Any thoughts or comments to elaborate on that?
I'm not really quite sure what the elaboration is. I mean, so they have said here for center-based programs that center-based programs would be required to offer at least 180 days of planned operation per year, and to offer at least 6 hours of operation per day. And so that's what they're proposing. And I guess one of the, one possible comment here is that some people are thinking about is whether it would make sense, instead of to have a certain number of days of operation per year, to make the requirement be a certain number of hours of operation per year. So that's one thing that some people are looking at in terms of the kind of increased dosage issue.
So instead of having 180 days and 6 hours per day, you would require 1,080 hours per year, which is the same number of hours. And then programs could have the flexibility, for instance, to have 5-hour program days, but have more days. I think it comes out to 216 days per year. And we know that for some programs, including here in Massachusetts, if you increase the length of the program day, children would be required to take an additional nap, and so there are questions of whether or not that really is meeting the intent of increasing the dosage.
Great. How do we elaborate on our own nap time capacity? Never mind. Okay. Sorry. In terms of the fingerprint checks, a couple of questions. First, is anything here asking for two different types of fingerprint checks?
No.
And
so
someone, okay.
Oh, sorry. Go on.
And then someone else followed up, also noted that in New York, for instance, it only allows fingerprints for an employee attached to a license. So there's concern about how they might comply.
Okay, right. So this is one thing that we were thinking of maybe commenting to say, instead of having the requirements that they've specified here, I mean, there are requirements about this in the Head Start Act, but, what we were thinking of saying is something, look at the Head Start Act and say something like consistent with the Act, that the background checks should be done in accordance with your own state's rules around this, because we think that that is going to be easier for people to follow. Number one, to just have one set of rules, and then number two, if there are conflicting rules, it would be clear that, to avoid the issue of conflicting rules. So first of all, just to clarify that point about are we talking about getting 2 sets of fingerprint checks? No. So what the rule says is, the proposed rule says that you would have to either get a state criminal history records check, including fingerprint checks at the state level, or an FBI criminal history record check, including fingerprint check. So it would be either the state check, including fingerprints, or the FBI check, including fingerprints. Now, I know, for example, here in Massachusetts, when folks get fingerprinted, I believe as part of the state requirement, that the fingerprinting is checked through the FBI database. And I think that's sort of the point of the fingerprinting, is to, capture offenses that may have occurred in other states than just the one state that you're licensed in. So anyway, so it's one check of fingerprints, and then right. So then I think and then you're saying in New York State that I guess it's from the question. It looks like it's allowed only once, and so I'm guessing that that question is getting at the requirement that the checks be redone every 5 years, and so again, perhaps we could comment something to the effect of you just have to follow your state's laws in this regard. I mean, then if they did choose to go ahead and implement a reg that was not consistent with one state law, under the Supremacy Clause of the Constitution, if there's a federal law, if a federal law and a state law on the same topic conflict with each other, the federal law would govern, and for this purpose, federal law includes not only federal statutes, but also federal regulations. So, but then you would have to work with, talk to Office of Head Start about, okay, well, how could we possibly comply with your reg given that our state says this? And so you might have to work, once the regs were finalized, and if that were the case, you might need to work with an attorney about that. Now, and also just to say another thought on that point, so for example, for the foster grandparent program, there are somewhat recent federal rules about getting foster grandparents fingerprinted. And so in Massachusetts, for example, though, the foster grandparents are not one of the entities that is allowed to get fingerprints. So, schools and other, child care programs and other programs are specifically allowed by regs to get these fingerprint checks, but the foster grandparent program isn't because, for example, in Massachusetts, you have to be a licensed child care provider or a school or some other things to get the fingerprint checks. So in Massachusetts, there are provisions under the foster grandparents regs for there to be a waiver of those regs where you can't get it within your state. So this might be something else that CAPLAW could comment on, would be to say, if they're going to propose regs across the board instead of tying them only to your state's regs, to allow for a waiver process if there are inconsistencies between the processes that are available in your state versus the ones that Head Start is requiring.
Great. I have two more questions that have come in, but I also want to acknowledge just some comments that have come in that I think you spoke to earlier. So one of the big elephants certainly in the room is extension of dosage or more dosage is great, extension of school year is great, extension of days and hours is great, but if there's no money, then it's a real challenge, and these rules then certainly decrease the number of kids who benefit from a Head Start overall. So I just want to make sure we're acknowledging the comments that are coming in stating that. But two questions, and I know you probably want to move on then. If you're looking at the Policy Council timeframe, we did get a number of comments from folks saying they were pleased to see the 5-year piece. A question to come in, will it be a block of time for that term limit or 1 year for one of, I'm sorry, will it be a block of time of a 1-year term or intermittent based on a child's enrollment? Not sure if I.
Oh, I think I'd have to go back and look. I think it would be 5 1-year terms, but they're not necessarily saying that they would be consecutive terms.
That's right.
So if somebody was, they had one child who was in the program and then they were on the Policy Council for 2 years, and then that child moved out of the program, and then, a couple years later they had a child who entered the program, then they were on the Policy Council again, then they could do that. But it's a total of 5 1-year terms.
Total, okay. And is there any definition of what constitutes a threat from a child?
Oh, you're speaking about the suspension and expulsion
provision? It probably does go back to that, yep.
So threat is not defined. There's a defined term section of the proposed standards in section 1305, and that a threat is not defined. I think the regs there speak to if a child's behavior is considered to be threatening to the safety of the program or other children in the program, but there's no definition for threat.
Yeah, it seems to talk about when children exhibit persistent and serious challenging behaviors, serious safety threat, right, yeah, exactly. So, right, there are a number of provisions we've noticed, or terms we've noticed in the regs that are not defined. Okay, so if we think we'll move on because we're getting short on time as expected.
So let's move on to Part 1303, which are the financial and administrative requirements. So the first section here in financial requirements, HHS made two major changes in the section. The first is that they removed the requirement that all Head Start grantees have to have an annual audit. Instead, they're adopting the same single audit threshold as in HHS's codification of the uniform guidance. So if an agency spends more than $750,000 in federal grant funds in a year, it will be required to have an annual audit. Otherwise, it wouldn't be required to do so.
And so we see this as a welcome change because it was a little unclear before when they required grantees to have an annual audit, whether that audit was the same thing or not, and if not, what was supposed to be in that. So we see this as a welcome change.
The second change is that they removed the auditor accounting system certification since, as they know, this is not something that auditors typically can provide as part of their audit process. Under insurance and bonding, the current regs have this long list of categories of risks that programs had to include in their insurance coverage. The proposed standards eliminate that and simply require agencies to maintain a documented process that assesses their own risks. Programs, however, will be required to consider the risk of loss that results from employee fraud. So that is something specific that the process would have to include. Under the section on protections for the privacy of child records, this is a big change. So HHS here is proposing to adopt privacy protections that are similar to those in the Federal Family Education Rights and Privacy Act, or FERPA. The new regs would require programs to maintain what they're calling a child record for each child, and this would include any documented information that's related to that child. And parents will have the right to inspect and amend child records. Parents would also be allowed to dispute any portion of the child record, and they may request a hearing to challenge information in the child record. After the hearing, the parents may, under certain circumstances, place a written statement that either comments on the contested information or it says why the parent disagrees with the program's decisions, and that contested statement becomes then a part of the child's record. And so when a program discloses that portion of the child's record, it has to also provide the parent's statement. The regs also provide further protections for what they're calling personally identifiable information, or PII, and they're borrowing the definition for the same term from FERPA. And programs have to obtain parents' written consent before disclosing any personally identifiable information, subject to 8 specific exceptions that are listed in the regs in Section 1303.22. However, just to note a difference from FERPA, there's a concept in FERPA called directory information, and this basically allows programs to set aside certain types of personally identifiable information. They can disclose that information as long as parents are given notice and the opportunity to opt out of disclosure. Under the Head Start regs, however, that's not going to be allowed.
And also, I would just comment here that so the programs would be required to obtain the parent's consent before the program could disclose personally identifiable information. The consent would have to specify what records would be disclosed and explain why and to whom the records would be disclosed. And, there are additional requirements around that. And so I guess we see ourselves as likely to comment on this section and to look at how integral the sharing of information is for Head Start programs, especially within CAAs, within the organization, because right now it talks about the Head Start program you have to get this consent to share information outside of the program, or at least that's the implication. And so I would like to comment about, making sure that if a Head Start program is located within an entity such as a CAA that provides multiple services, that that whatever rules they have in this regard not restrain the ability to share information in order to integrate services. and we may have some other comments regarding sharing of information with third parties. And of course, we would always want organizations to get the parents' consent, but we just might want to look at whether there might be a little bit, the consents could be drafted a little bit more broadly to encompass the type of typical situations where Head Start programs have to share information either within the organization or with third parties.
So one other requirement for the child record is that programs have to maintain a list of all individuals and organizations that have requested or obtained access to personally identifiable information from the child record. And there's just an inconsistency there where the preamble to the regs say you have to maintain a list of all individuals or organizations that have requested or obtained access, whereas the regs themselves just require you to have a list of those who've obtained access, and so we're going to be seeking clarification on that issue. Moving on to delegate agencies, and for Head Start programs that have delegate agencies, the new regs really streamline the appeals process for grantees that are looking to terminate funding to a delegate agency, and I think that under the current regulations, it's a pretty extensive process.
Where in fact, we would say even more process than is permitted for, for grantees, yeah, themselves, especially those that find themselves in designation, designation renewal.
Going on to the next section on federal interest in facilities, the proposed standards define for the first time what a federal interest is in property. And they also define major renovations to mean renovations that cost more than $250,000 or minor renovations that are included in the purchase application.
Whereas right now, the term major renovations gets into a lot of more detail than that.
Right. And this section on facilities also, just to note, only applies to major renovations. So that's subpart E of Part 1303. On refinancing, the proposed standards clarify that programs are allowed to apply for funds to pay for refinancing costs, and they also clarify that the purchase of property includes both principal and interest payments.
And we think it's important that they clarify that because that's a requirement in the Head Start Act itself, which says that basically, like, if you bought a building but you didn't charge any of the mortgage to Head Start but you did charge interest, you would have to go, under the current rules, you would have to go through the Part 1309 approval process, and that, I think, sometimes that's tripped up grantees who didn't realize that, so it's good that they're specifying that here in the regs.
Going to third-party leases and occupancy arrangements. So the rules here are really dealing with grantees who are looking to use federal funds to construct or to conduct major renovations on leased property, so not property that they own outright. And so here, grantees would be required to have leases in place for at least 30 years if they're doing construction work, and if they're doing major renovations, leases that are at least 15 years. We see these lease terms as fairly long, and again, would welcome feedback from the network on whether this is, something that you run into before, having to have a lease in place, and if 30 years and 15-year lease periods is really feasible. The last section just to highlight in Part 1303 is transportation, and here the new requirement really is that programs have to take steps to ensure that no child is left unattended, and that's either on the bus or on the vehicle or at the pickup spot. And that's really in response to a few incidents where children have been left unattended. So moving to the last sort of substantive section, Part 1304, the federal administrative procedures. And here, we just want to highlight a few of these. First, the appeals procedures. So under the current regs, there's an extensive appeals process. The new standards would eliminate those procedures and instead just adopt the Departmental Appeals Board, or the DAB procedures. We'll skip monitoring and suspensions with notice, and then looking at termination and denial of refunding. One change to highlight here is the definition of financial viability for the purposes of terminating or denying refunding. Under the current regs, financial viability means the capability of a grantee to furnish the non-federal share of the cost of operating a Head Start program. whereas under the new regs, the definition of financial viability is much broader. And here, the regs say it means an organization is capable of meeting its financial obligations, balance funding and expenses, and also maintaining sufficient funding to achieve organizational goals and objectives, which, again, goes beyond sort of, being able to finance the cost or the non-federal cost of operating a Head Start program, and, query whether it makes sense to tie financial viability to funding to achieve organizational goals and objectives, which are a little bit more prospective and aspirational. We'll skip legal fees and just talk quickly on DRS. HHS is not proposing to make any changes, any substantive changes to the DRS regs. That's subpart B of Part 1304. ACF is currently conducting a study on DRS, and they've said that once they get the results of that study, that they may consider making further revisions to the section. But since they're not making any changes to the section, they're not soliciting comments on this section at this time, even though we know that many grantees have had thoughts or reactions to DRS. That really covers the substance of the regs. There's a new Part 1305, which consolidates all the definitions that are used across the proposed standards into one section. So there are definitions that you may want to read further there, but essentially that's sort of the overview of the standards. And again, CAPLAW is intending to submit comments, and if you have anything that you want us to include, if you could send those to me, to Veronica, by next Wednesday, August 12th, the end of the business day, that would be great. If there are any other questions, Denise or Cashin, we'd be happy to take those now too.
Okay, a question came in about lease terms. They were told not to have any contract or leases beyond 5 years due to the new contract lengths from the regional office. How does that fit with the long-term leases and renovation around 30-year terms?
Well, certainly under these regs, they would require a long-term. Well, if you were leasing to renovate, they would, and going to renovate, they would require a lease of at least 15 years, and otherwise at least 30 years. So, that would seem to contemplate longer-term leases. Certainly in the facilities regs, there is no requirement that we at CAPLAW are aware of that says that you can't lease for longer than 5 years. I mean, we certainly understand that the regional offices may be looking at designation renewal. I guess one thing that we at CAPLAW advise people to do, advise community action agencies to do in all of their leases and contracts, is to include a provision that says that if we do not get funding for this lease or this contract from the federal government, or many CAPs, of course, receive funds through the state governments as well, so federal, state, or other funding source to fund this lease or this contract, that we can terminate upon X days notice. And so I've worked with CAAs where they just, as a matter of course, include that language in all of their contracts and have been successful in doing that. And so that would be what I would say back to the regional office is, if we're going to go out to this landlord and we can get them to agree to give us a funding out clause, should we not, should we end up in recompetition and lose the program, then, you ought to be okay with it. And actually, frankly, I think that, anyways, I think that's the best way to address that situation, because even if Office of Head Start isn't requiring you to have just a 5-year lease, you want to make sure that you have a longer lease than that, you want to make sure that you have language that gives you an out if you lose your funding, so that you won't be saddled with a long-term lease.
Great, thank you. The last two things I have here really kind of go back to the dosage issue, and I'm not sure if there's going to be much clarification you're going to be able to provide at this point, but I think it raises some of the challenges that find their way into comments. The first one would be the challenge of a full day dosage in a classroom or in a program that is working in partnership with universal pre-K in school systems, and what kind of negative impact that might play with a school district If you need the classroom for the full day and the UPK site also needs the classroom for a part of the day and you've worked jointly in the past, that may challenge the relationship going forward. And the second one is that sometimes it looks like for some organizations the full day dosage will mean that some kids get no dosage while some kids get the full dosage. So instead of serving 206 kids for half a day, you're going to serve half that amount, 103 for the full day. So any thoughts, concerns? Is that something that would find its way into comments or should through us, or what are your thoughts on that?
Right. Well, we definitely know that that is a comment that is, in terms of especially for programs that are collaborating with the local schools, whether it be through UPK or just simply use of school space, that the dosage requirement could have a negative impact on their ability to provide services. So I would urge individual programs to comment on that. And also, I think I just want to say that, CAPLAW is going to do comments, as we've said, and we've highlighted a lot of the areas, but I think that I would urge everybody on the call, if you have a strong feeling about one or more of the provisions, to submit your own comments as well, and they don't have to be, written by a lawyer or the most eloquently written comments or anything like that. But I think that, if people are, commenting on how this will affect them, Office of Head Start will take notice. And even though, Ann Linehan said, we don't want everybody, photocopying, say, CAPLAW's comments and submitting, 500 copies of that. I think that's what she was getting at. I don't think she was trying. I just want to make sure people understand. My impression is they want comments from across the country. So I would say, it's pretty easy to comment on the website. It's web-based, but there are different ways you can do it. You can do it by mail. I think you can do it on the web, and it's, they give various options, and we've outlined that in our article that you'll be getting if you haven't received that article already. So again, I would urge people to raise exact issues like this one here so that they can see that, this is a great idea, perhaps to, extend the dosage, but this is how it will impact us. And again, maybe that's an area where, a change in the number of hours as opposed to days or something like that could address that issue as well.
I think that's a great recommendation, Eleanor. I think they're going to get a lot of comments from perhaps things that are very consistent for very large communities, for instance, or there's going to be some consistencies in the comments they receive, but our network is very adept at meeting local concerns, and we serve all shapes and sizes of communities. So I think that's great advice, that if you have a situation that's because of your community, because of the nuances of how you've created the system, and there really aren't going to be other providers or options for families to access, especially in rural or smaller communities, that submitting a comment describing your particular situation makes a lot of sense. And again, like Eleanor says, you don't have to be an attorney to submit comments, writing straightforward, direct, and I would bold and highlight perhaps some of your specific concerns, but a one-page piece or a two-page thing I think would be totally acceptable for your unique situations, and you should feel empowered to do that. And if there are things that you'd like to send our direction as well, please do that here at the partnership.
And also just to go back to the proposed regs themselves, so they do give this option of locally designed program options, and so, but in order to do that, you would have to request a waiver, and that would have to be approved by HHS every 2 years. So there may be some flexibility under the regs that they're proposing, but I still think it's worth sharing with Office of Head Start what your own experience is in your community. We see here there's a question about, do background checks also extend to policy council members and board members and volunteers? The language in the statute and then the regs is for staff. So I would say not, except that it's possible that your own state licensing rules may require it. I wouldn't necessarily think for policy council or board members, but for classroom volunteers, the state regs may require it.
Great. All right, well, I think that exhausts pretty much the questions. We'll review them and see if there are any that we want to follow up with in writing, and we can send them your way, sure, to CAPLAW. And here's this last slide here makes me want to go to Florida right now. I just want to jump off that pier. There are conferences coming up. Again, we're going to have a Head Start Town Hall at the convention, And then I know that at CAPLAW's annual conference next June, there's always some really great Head Start content. So encourage you to take a look at those events as an option in your planning for next year. Eleanor or Veronica, any last comments you'd like to make before we sign off?
One last comment I'd like to make is we have heard a rumor that the comment period may be extended. So, but again, it is just a rumor, so we don't know for sure, but there is some potential for that out there, so stay tuned for that. If it is, of course, we at CAPLAW will let the network know, but just to let you know that that's a possibility. But I should say, even if that's a possibility, don't let that delay you in taking a look at the rules, and hopefully our CAPLAW article and hopefully this webinar will provide a roadmap to you for looking at the rules. And if you look at the Federal Register notice, it will seem rather long and daunting because most of it is the preamble, which is very interesting if you care to read that. But just if you want to just focus on the regs themselves, I would urge you to do that. And so you just have to flip back in the notice a bit to the actual regs that they're proposing. And I would urge you to just sit down and look at those, share them with your Head Start staff, and have them look at them as well to see if they have comments or concerns. And as Veronica has said multiple times, please do share your comments or concerns with us by sending an email to Veronica, whose email address is on the opening slide there, and so that we can determine whether to include those comments in our own comments. So thank you for taking the time to listen today, and we hope to hear from some of you as well through the comment process.
Great. And just to let folks know, we also attended a meeting with the National Head Start Association last week, and their series of comments are also very thoughtful and in-depth. So I think you can be well assured that the experts in the field on Head Start are definitely paying attention to a lot of the issues that are coming out of the proposed rulemaking. So again, we'll get you copies of the slides, we'll get you a copy of CAPLAW's article, and please keep those questions coming in and get the comments to CAPLAW by the 12th. So with that, I think we're going to sign off. Thank you so much for joining us, and reach out if you have any questions following today. Take care, folks. Bye-bye.
Thank you.